कूलली अपना आर्ग्यूमेंट कंपोज कर लो, वी आर नॉट इन हरी, एंड आप क्या कहना चाहते हो वो बताओ, घबराओ बिल्कुल मत।
डेथ रिवाइव नहीं हो सकती, ब्लैकलिस्टिंग रिवाइव हो सकती, इसलिए ओनली मनी वुड नॉट बी सफिशिएंट।
कोमा में रहता है तब भी कोई काम कर ले।
Ultimately, it is boiling down to efficiency and efficacy of the
Efficacy.
ट्रिब्यूनल को स्टे का पावर इसलिए नहीं दिया कि एवरीथिंग कैन बी कंपनसेटेड इन टर्म्स ऑफ मनी, every loss, every
damages are compensation,
everything can be compensated. That's why power is still work should go on.
But kindly see now section 19.
7 का हो गया आपका इतनी
So what was your argument on 7?
7 की suppose Malad, if there is agreement between the parties,
That we are going on a presumption there is a works contract agreement. There is an agreement pertaining to a works contract.
Malad, I am talking about I am arguing on the only
अगर वो contract ही नहीं है, agreement नहीं, तो मध्यस्थता तो लगेगा नहीं, तो issue arise.
no, well, I am not saying like that. कि अगर there is a contract between the parties and suppose anybody is prohibiting us to participate in the tender process, any other person who is not party to contract, whether I could be able to
because a party who is a person who is not a party to the works contract cannot blacklist you.
उसको
Situation is that it's
what you are saying is that effect of blacklisting
effect
is
of blacklist
you are not able to participate in other contracts.
on other contract.
Those are not works, may or may not be works
May
contracts.
not be.
That is not the question. That is the effect of blacklisting. Party, they are not going to say this party which blacklists you does not say you will not participate in any other contract. They say we will not deal with you. That's blacklisting.
As a blacklist.
It's a self-imposed restriction on themselves that we will henceforth not deal with this contractor. That's blacklisting. But the effect of that is that any other entity, government entity, says if somebody has been blacklisted by any entity, we will not deal with them. So effect is on them. Those contracts may or not be work contract, maybe of the state, maybe outside the state. So that is not the question. Assumption is between you and the employer, there is a works contract, or there is a breach of that contract, or a dispute emanating out of that contract. In those circumstances, if the step of blacklisting is taken, what is the remedy available to the contractor? Can he approach Madhyastham in a reference? If he can, what can be the scope of reference? Can it only be restricted to wrongful blacklisting, or it can be damages for wrongful blacklisting also?
My submission would be before this honorable court, my lord. Maybe kindly see section 19.
Yes.
deals with the revision.
Deal with 2.1 देख लें 2A. My entire argument based on this fact, my lord, the tribunal doesn't have a declaratory power so far as the blacklisting is concerned and ascertaining the futuristic.
Why do you say it does not have declaratory power?
My lord, अगर if see this section,
How the monetary claim can be allowed without giving declaration that termination is illegal? Suppose termination has been upheld, then you are not entitled for single pay.
Unless the tribunal declares termination to be wrongful, then there can't be a
if my lord see the aim and object of the act.
Yes.
तो क्या पहले 2A पढ़िए ना, 19(2)A पढ़िए। 19(2)A तो कहता है as exercises jurisdiction not vested in it and there is no power to grant injunction. तो ये 19(2)A
19 ऐसे मतलब कि if अगर it is a barred by law, they don't have a right to pass any declaratory order. My argument is based on that.
Where is the
Highcourt will interfere in the revision. It is 19(2)A. Yes, he is simply a good ground for interfering in the revision.
So far as the
It is
blacklisting,
barred by law, but we are not dealing with the case where it is barred by law.
no, my lord, my humble submission.
Which forum the remedy lies?
My lord, my humble submission. If the tribunal has exercised beyond the law, because the tribunal doesn't have a power to declare it, can you see the object?
What do you say? Tribunal doesn't have a power of, what is power of declaration? If there is a termination and the contractor says this termination is wrongful, I should be compensated for this wrongful termination. What is the relief that he will seek? declare the termination to be wrongful, and then give me damages.
Consequential relief of damages.
If it doesn't ask for declaration of declaring the termination to be wrongful, where is the question of damages?
My lord, tribunal has a power to adjudicate the breaches of the contract.
What will the tribunal declare? Whether there is a breach or no breach? If there is no, what is declaration? Declaration is returning a finding on a material fact. Tribunal declares there is no breach. Tribunal declares the termination is wrongful. Then comes the consequential relief, either specific performance, which the specific relief act says can't be granted. Only question is damage.
Money.
Consequential
Compensation.
And there is one more thing. Once termination is declared to be illegal, then as a consequence, the order of blacklisting will also go because it's a consequential order of termination. So consequential relief में order of blacklisting भी खत्म हो गया. Apart from damages.
My lord.
If the tribunal holds that termination is valid, let's say the tribunal holds contractor is at breach and termination is valid. Can the tribunal hold blacklisting is wrong?
Certainly not, my lord.
It can. By giving the reasons that though the termination is valid, but certain such circumstances of extreme public policy are not attracted and therefore the blacklisting is wrong. Still, there can be an order of declaring blacklisting to be illegal.
If your argument are accepted, that means the contractor is required to get all the issues decided by some other forum and then file an execution for recovery before the tribunal. The tribunal will decide all the issues.
Address this honorable court for
अभी आएगा मिश्रा जी बैठो मिश्रा जी
But I have patience.
हाँ मिश्रा जी
We are not in hurry.
एडिशनल जी साहब आप क्या निर्देश लेकर आए हो
Short कर रहे हैं क्या?
Proceed कर रहे हो
Lordship permit में Lordship का fourth question
आपका हो गया वो? आपका हो गया?
बस
चल रहा
You will get your chance, Mr.
बैठिए 5 मिनट रुक जाइए
बस 2 ही मिनट.
अरे आराम से टेक योर टाइम आप फुल्ली अपना आर्ग्यूमेंट कंपोज कर लो वी आर नॉट एट एंड आप क्या कहना चाहते हो वो बताओ घबराओ बिल्कुल मत बिकॉज योर आर्ग्यूमेंट विल हैव लॉट ऑफ बियरिंग ऑन अवर डिस्कशन ठीक है पूरा बताइए आप
My only submission before this honorable court, because it has an impact of future contract and it cannot be computed by way of any means ascertainable.
आप थोड़ा सा एक्सीड कर रहे हो ये पॉइंट अमनीश जौहरी साहब ने उठाया था कि 77A में जो है हम अदर कॉन्ट्रैक्ट से डील नहीं कर सकते. अभी आपका जो ब्रीफ है वो इतना है जिसके ऊपर अमित जी ने आपने वो देखिए रिले रेस देखिए रिले रेस में पैटर्न जो लेते हैं ना पैटर्न लेके दौड़ना पड़ता है.
ब्रीफ में तो छोड़
मिला है पैटर्न क्या मिला है आपको पैटर्न मिला है वेदर ऑर्डर ऑफ ब्लैक लिस्टिंग is computable in terms of economics or finance or money or not. ये आपका बैटर्न है उसी को लेके दौड़ना है आपको अगले फेज तक. उसका फिर आप अपना बैटर्न दूसरे को दे दोगे वो दूसरे बिंदु पे बहस करेगा. यू कैन नॉट चेंज द ट्रैक. देखा है ना रिले रेस देखिए नहीं देखिए
देख
Yes.
मतलब my only submission will it could not be computable in light of the section 7 and the blacklisting has a impact of the other contract so that it cannot be go before the top.
before which forum it should be?
मतलब
Which forum will this entertain?
under 226 मतलब
226. So in 226, High Court can recommend the certainly
नहीं
compute the
26 में एविडेंस ले सकता है हाई कोर्ट
no मतलब
एविडेंस ले सकता है
no
समरी जुरिस्डिक्शन है हाई कोर्ट
because it's a violate
of facts right.
it's violates 191G.
for the purpose of the ascertaining the amount of compensation or etc. Then how it can be entertained under 226?
For the purpose of ascertaining money, it cannot be. So far as the blacklisting is concerned, it could be. Rest part ascertaining money is not.
Ascertaining the money can't be done by the High Court and not by the tribunal.
No.
So then, when you will challenge the termination before the tribunal, you can challenge the blacklisting also. Tribunal will examine both the cases, both the issues. Then what will be the purpose to relegate any person to the contractor or to different forum? for challenging the action of the department, cancellation go to Madhyastham, and for blacklisting to go to some other forum.
Why to compel respondents to face two proceedings for the same issue? They go to different forums.
And what
There's
is
a burden on the state.
on declaration, they come to contrary views. One says contractor at fault, the other says not at fault.
Not for them.
Then who will resolve?
All the issues are liable to be decided by one server.
फिर फोरम हंटिंग भी बैंड है लॉ में, सीपीसी खुद ही कहता है फोरम हंटिंग नहीं होगी। दूसरा जो है मल्टीपल फोरम एक ही रेमेडी के लिए नहीं होंगे, या तो आपको बताना पड़ेगा दो रेमेडी अलग अलग हैं, दे आर सेपरेबल फ्रॉम ईच अदर। सोचिए
Order to rule to bar the subsidy.
वी आर जस्ट गिविंग यू फूड फॉर थॉट, ठीक है? सोचिए, कल भी बता सकते हैं आप, ऐसा नहीं है कि आप आज बोल के कल नहीं बोलोगे। लेकिन सोचिए, आपको एक हिंट दिया था मिस्टर छाबड़ा ने कि भाई लॉस भले ही कितना भी इरिपेरेबल हो, बट किसी मैकेनिज्म, किसी प्रिंसिपल, किसी फॉर्मूला में उसको आप जो है राइटली और रॉन्गली कंप्यूट कर सकते हैं। सेटिस्फेक्शन तो कभी नहीं मिलेगा, क्लेम में कभी कोई सेटिस्फाइड नहीं होता।
उसमें मैं छाबड़ा साहब से थोड़ा डिफर करूंगा।
उसको डेवलप करो आर्गुमेंट को, बताओ।
डेथ रिवाइव नहीं हो सकती, ब्लैक लिस्टिंग रिवाइव हो सकती है। इसलिए ओनली मनी वुड नॉट बी सफिशिएंट।
कोमा में रहता है तो तब भी कोई काम कर ले।
Blacklisting revive or something means you are challenging the order of blacklisting. That can be challenged before the Madhyastham.
And the argument will boil down.
Consequential relief.
There is no power to grant interim relief.
That's the difference. Power to
That's the
grant-
only argument.
That.
Main concern of everybody is there is no power of.
There is no power under section 17.
Assuming it was to be declared that blacklisting will not take effect till the tribunal upholds termination. Then
Certainly it has to go before.
you will be very happy, let it go to Madhyastham. Then everybody will say that.
नहीं होगा 10 साल में, तो फिर कॉन्ट्रैक्टर नहीं, कॉन्ट्रैक्ट पूरा नहीं हो जाएगा, कॉन्ट्रैक्टर की लाइफ पूरी हो जाएगी।
हाँ, 10 साल में डिसाइड नॉर्मली नहीं होगा।
जो कमर्शियल लाइफ रहती है कॉन्ट्रैक्टर की 10 से 15 साल रहती है, फिर नया कॉन्ट्रैक्टर आ जाता है।
So ultimately it is boiling down to efficiency and efficacy of the tribunal.
ट्रिब्यूनल को स्टे का पावर इसलिए नहीं दिया कि एवरीथिंग कैन बी कंपनसेटेड इन टर्म्स ऑफ मनी। Every loss, every
Damages are compensation.
everything can be compensated. That's why power of state work should go on.
But it is
the continuation.
so far as the termination is concerned, it is only confined to particular termination.
Ultimately, every contractor is working for money, for profit, so he can be compensated for that.
But blacklisting always restrained to participate in further any other process, any other tender. That is only difficulty.
Person can be hanged by following a due process of law. If blacklisting has been done by following a due process of law, that is permissible. It can be declared illegal by the court in due process.
Manoj, in case of
कोई चीज इस प्रिंसिपल पर सोचिए और विचार दीजिए
जी
कि क्वांटिफाइबल है कि नहीं। हो सकता है उसके बाद भी यू मे बी एबल टू से क्वांटिफाइबल होने के बाद भी
इफेक्टिव रेमेडी नहीं है।
इफेक्टिव नहीं है, तो उसको डेवलप करिए थोड़ा सा। वी आर ओपन टू ऑल काइंड्स ऑफ आर्गुमेंट्स, बट वी वांट सम न्यू आइडियाज टू कम। उसको डेवलप करिए ना। क्वांटिफाइबल है लेकिन इफेक्टिव नहीं है, क्वांटिफाइबल नहीं है इसलिए इफेक्टिव नहीं है। दोनों हाइपोथेसिस को डेवलप करके बताइए ना।
Next.